Tonight's courtroom hearing takes a dramatic turn as Jacob Edwin Mullins appears by video conference to answer serious felony arson charges. Prosecutors accuse Mullins of burning down his parents' home, but from the very beginning, the hearing spirals into tension and confusion. Instead of focusing on the charges, Mullins repeatedly interrupts the judge, questions the authority of the court, and makes strange statements about the legal system being broken. As the judge attempts to explain Mullins' rights and upcoming court dates, the defendant continues making bizarre comments that leave the courtroom visibly concerned. His behavior raises major red flags, not only about his willingness to follow court orders, but also about his mental state. The judge ultimately decides that Mullins poses both a public safety risk and a flight risk, denying him release on a personal bond and setting a $10,000 cash surety bond instead. The court also imposes strict conditions, including a no-contact order with his parents and a requirement to stay at least 2,000 feet away from them if released. As the hearing grows more chaotic, the judge orders a community mental health evaluation to further assess Mullins' condition. This case quickly becomes more than just an arson hearing, it turns into a tense confrontation between the court and a defendant determined to challenge the system at every step.
Feigelson, if you would enter your appearance, please.
Yes, Your Honor. Good afternoon, Assistant Public Defender Stephen Feigelson on behalf of Mr. Mullins, who's present by way of video conferencing this afternoon.
All right, thank you. Mr. Mullins, this is a felony complaint indicating on or about January 24th of 2025 at 216 East Thomas Street, Lansing, Ingham County, Michigan. Sir, count 1 alleges that you did willfully and maliciously burn, damage, or destroy by fire or explosive personal property with a value of $1,000 or more, but less than $20,000. That is contrary to law. It is a felony, carries a maximum penalty of 5 years and or $10,000 or 3 times the value of the property damaged or destroyed, whichever is greater. Do you understand the charge and the maximum penalty, Mr. Mullins?
I understand your perspective of what occurred and outside
well,
of that.
hang on. Before you go too far, this is just what's written on the paper. You are presumed innocent. Let me finish, okay? And you'll understand why I'm saying this. You are presumed innocent. So we want to make sure that you don't say anything today that can be used against you. So when you get to talk with your attorney in private, that's when you're going to want to talk about what happened or didn't happen. I can only tell you what the charge is and the penalty is, and then you'll talk to your attorney and they will help you prepare a defense against the charge. Does that make sense?
I'm 29 years old. I understand. Like, you know what I mean? I get it, bro.
Good. Okay. All right. Then, Mr. Mullins, you understand the charge and the maximum penalty. You don't have to agree to it. You just understand. Is that right?
Right. Yeah. No disrespect.
Okay. Perfect. All right. Now, you do have rights as well. You have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury, and at that trial, you can present or confront witnesses. If they would not appear, the court can order them to do so. You also have the right to a lawyer, and if you cannot afford one can be appointed for you at court expense. Additionally, you are presumed innocent, as I said earlier, and if you are found guilty, it has to be beyond a reasonable doubt. You also have the right to remain silent. Anything you say or write can be used against you, and you always have the right to have a lawyer present with you at any time that you are questioned. Do you understand those rights, Mr. Mullins?
You said read anything you say or write can be used against you? Did you say that?
Yes, I did say that. Yes, sir.
Me no speak English on that one.
Our office on another matter, Your Honor.
Okay, thank you. So, Mr. Mullins, what we're going to do is we have two hearings set for you on this. A probable cause conference, which is the first hearing. That is February 6th. That's at 8:30 a.m. with Judge Simmons. Excuse me. You are allowed to appear remotely on that. So that's why you will have a colored sheet. I think it's kind of a bluish green. Yep. Okay, you should have that. So that's on the 6th floor of City Hall, Courtroom 4. And that's February 13th at 8:30 a.m., also with Judge Simmons. So you've got the notice and the Zoom instructions, correct?
Yes.
Good, good. Okay. Now, is there anything I've told you so far that you do not understand?
The one thing I didn't speak English on, yeah, but other than that, yes, everything else I did. I'm an artist. I've been writing a lot of things, so when I write stuff, it's like almost like, you know what I mean? So that's just a arbitration contract thing that I didn't like. So I mean, we'll settle through that. So I would like to just voice that. Other than
We
that,
could
no
just
disrespect.
move
Yes.
forward, sir. Appreciate the.
Correct.
Yeah, you'll talk about that with your attorney. Absolutely. Okay, so Mr. Mullins, I'm going to stop the live stream so that I can protect.
I ain't got nothing, and y'all ain't give me any tools to get a job since I've been released from your guys' care. Now, I don't really know what's going on with my support system, but it's
This is my turn to talk, Mr. Mullins. Okay, you don't want to talk about that because, like I said, you're gonna you might say something that can be used against you. So the court's going to look at two things, Mr. Mullins. I'm going to look at whether or not you're a flight risk and whether or not you are a danger to the public. In regards to that, I'm going to look at your criminal history. I'm going to look at the allegations. I'm going to look at your ties to the community, your employment status. You live with your parents. I look at all of those to determine two things. I do have a concern for the safety of the public. On the matter that I arraigned you on first, the arson, you are presumed innocent, but as I look at the allegations, it presents a concern to the court for the safety of you and any other individuals that reside in that location. I understand that would be your parents.
1995.
Okay,
Trust me.
this is my turn, sir. Okay, so based on that, I'm not going to grant you a PR bond because I don't find that that is sufficient to specifically hear your parents. The court is going to set a cash surety bond on this of $10,000 to ensure your appearance. We're not done yet, sir. Okay, now, first of all, the condition of your release is do not miss any court dates and do not violate any state or local laws while you're on bond. You're not to possess, purchase, or consume any alcohol or controlled substances without a prescription, and you're not to leave the state of Michigan without permission from the court. You also are not allowed to possess or purchase any firearms, ammunition, or dangerous weapons, and you will have to report to pretrial services so that they can set up any pretrial supervision that may be necessary. That's either a phone or an in-person interview. Now, I'm also going to tell you, you cannot have any contact with Daniel Mullins and or Barbara Mullins. You cannot call, write, page, email, text, no electronic communications of any kind. You can't have anybody else contact them on your behalf, and no threatening, harassing, or molesting behavior towards them or anyone else. Additionally, you cannot go within 2,000 feet of where where they're located at any time, including work, home, or school. So what that means is if you have property there, someone can go and get your property and get it for you, but you cannot go there and you can't have any contact at all. Also, you're unable to give me an address at this point. So if you are released, you have 24 hours to notify the public defender's office of the address where you're staying. If you don't do that within the 24 hours, the court then sets a bench warrant for you. Do you understand that? Do you understand what I'm telling you, Mr. Mullins?
I understand that our system's broken and I'm just a little cog chilling. Hi, I'm Cog. Nice to meet y'all.
Okay, all right, let's go over the other file then. This is, again, the 24-03520. Judge Simmons has ordered that you be remanded on that case file because you failed to appear for the probable cause conference. So you will not be released before that hearing that is to be set. Do you understand?
Yeah, y'all tweaking.
All right.
You guys know I have no clue what the hell y'all are doing. You have no details. You're making a bunch of judgments on very, 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 very misguided details. And the frail line understanding that you understand.
You're going to talk with your attorney.
What's the Rotary Club? Who am I? Do you guys know who I am? My name is Jacob Edwin Mullins. You guys know who I am. That's crazy. You guys are playing silly ass games.
Did you have anything else?
I do not, Your Honor. Thank you.
Thank you.
And I am going to order a CMH evaluation on that new file as well.
All right. That. That's about the one good thing you've done today, and it's not your fault. You're an amazing person, I'm sure, and I'm not trying to hurt your feelings or like I'm a frustrated individual. So let me just say, like, I'm sorry for the disrespect. I know it's not your fault necessarily, but this is just a large.
This courtroom hearing quickly turns chaotic as Jacob Edwin Mullins appears before the judge by video conference to face serious felony arson charges. According to prosecutors, Mullins is accused of setting fire to his parents' home, leading to major property damage and raising immediate concerns about public safety. But instead of calmly responding to the allegations, Mullins spends much of the hearing challenging the authority of the court and making bizarre statements that leave everyone in the courtroom stunned. From the very beginning, the judge attempts to explain the charges, Mullins' legal rights, and the next steps in the case. However, the defendant repeatedly interrupts the proceedings with confusing comments about the system being corrupt and references that resemble sovereign citizen-style arguments. His unusual behavior creates tension throughout the hearing and makes it difficult for the judge to maintain order. As the court reviews the situation, the judge determines that Mullins cannot be trusted to safely return to the community without strict supervision. Because of the severity of the allegations and concerns that he could either flee or become a danger to others, the court denies him a personal recognizance bond. Instead, a $10,000 cash surety bond is set along with several strict conditions if he is eventually released. Those conditions include absolutely no contact with his parents, staying at least 2,000 feet away from them, and reporting his residence to the public defender's office within 24 hours of release. The judge also orders a community mental health evaluation after observing Mullins' erratic and unpredictable behavior during the hearing. What begins as a standard bond hearing ultimately transforms into a tense courtroom confrontation filled with interruptions, confusion, and growing concern over the defendant's state of mind.